Good morning, everybody. Today we have a conference on the relationship between traditional knowledge, identity, and cultural appropriation from the UNESCO 2003 Intangible Cultural Heritage Convention to the new GRAC Treaty adopted by the WIPO. The conference today is organized by UNESCO Chair on Intangible Cultural Heritage and Comparative Law of the Department of Law and Digital Society of the University of Rome Unitelma Sapienza. And we have the opportunity to have with us a guest speaker, Professor Lukas Lidzinski. Professor Lukas Lidzinski is Professor of International Law at the University of South Wales of Sydney. He is one of the most famous and influential author and scholars on international heritage law. One of the book that he is author is on international heritage law, and this book represents a milestone on the studies on this topic. He is a great expert on the not only on the intangible cultural heritage, but also in cultural heritage in general. And it is also editor-in-chief of the Australian Journal of Human Rights. We are very happy to have the opportunity today to have with us Professor Lukas Lidzinski, that is starting a period of visiting as a visiting professor at the University of Rome Unitelma Sapienza. After his speech, we have the opportunity to discuss with the two other colleagues, Professor Benedetta Ubertazzi. Benedetta, she is not only a close friend of mine, but she is one of the most influenced professors on in intellectual property. And especially she studies for several years the relationship between intellectual property rights and cultural heritage. The last book that Benedetta wrote was about this relationship and about how to manage this kind of relation between different legal international instruments. After Benedetta, we asked to our colleagues Tiago Burkhardt to discuss the presentation of Lukas Lidzinski. Tiago is a researcher at the UNESCO Chair on Intangible Cultural Heritage, and he is specialized on the indigenous people and cultural heritage of indigenous peoples. So without waste other times for my introduction, I would like to give the floor to Professor Lukas Lidzinski. Please, Lukas.
Thank you, Pierluigi. Thank you for listening. So it is such a pleasure to be here visiting Unitelma Sapienza. I've been very impressed by the intellectual community here. So my big thanks to Pierluigi for inviting me to come and spend some time here furthering my research and learning with and from you. So the topic of today is this intersection between traditional knowledge, identity, and cultural appropriation, sort of examining the UNESCO 2003 Convention for the Safeguarding of the Intangible Cultural Heritage and the 2024 Treaty on the Genetic Resources Associated with Traditional Knowledge of the World Intellectual Property Organization. So we kind of take those two as sort of the main milestones in the field to ask these important questions about what happens to indigenous knowledge. But what do I mean about indigenous knowledge in international law? Well, specifically, I want to focus on traditional knowledge, or TK, which is this knowledge that comes from indigenous peoples and local communities, even though that's an equivalence that a lot of indigenous peoples advocates contest. But it comes from indigenous peoples and local communities, and it is the idea that through the ways these communities have engaged with nature around them, they have developed specialized technical knowledge, which offers pathways for well, a lot of it is about medical treatment, but it can also be all sorts of industrial applications of natural knowledge. So we tend to think of traditional knowledge in the context of biopiracy, or this idea that, you know, people like to say that the cure for cancer is somewhere in the rainforest. We just haven't found the right plant yet. And we need to rely on indigenous peoples and local communities as partners to identify which plants have medicinal properties or other industrially applicable sort of properties, and how to harvest them and use them in a productive sort of way for the broader community. So it's very much closely related to pharmaceuticals and the things that we can turn into products. Now, the techniques for the extraction of these compounds and the extraction of these properties tend to not feature into a conversation about traditional knowledge. The idea is that the knowledge is about the plant itself and whatever chemical compound it contains, and that the technique for extraction is sort of handed over to the quote-unquote Western pharmaceutical company. So I want to make this clear because to the extent that we compare traditional knowledge to patent law as a category of intellectual property protection, patent law focuses a lot more or privileges technique over the product, even though the product is still, of course, there, right? Because ultimately the object of protection is the product a lot of the time, whereas traditional knowledge kind of pushes technique to the background and focuses on the product instead. And that difference is important, not just so we're right about things and put them in the right boxes, but it has an implication to how the law tends to downplay the agency and the importance of the knowledge of these communities, right? So these communities tend to be treated a lot of the time as just someone who kind of, out of sheer luck, stumbled upon that knowledge and is lucky to have it, or is just lucky to be in an area where that plant exists. And we tend to kind of disregard all the, well, the technique and the centrality of their science, right? We tend to look at indigenous knowledge as not really science in the Western world in a patent sort of context, and in some ways the Genetic Resources and Associated Traditional Knowledge Treaty, and I'll start calling it the GRATC Treaty, does or reinforces that assumption. So why is biopiracy so important in our history? So there's always been attempts at preventing or inhibiting biopiracy, or the taking off the natural miraculous plants from one country to another, because there's a sense that these countries should be able to exploit the plants that they found and that they have in their territory and that they have developed. But there are a lot of examples out there in which these efforts to create monopolies in favor of countries and communities, especially in the developing world, have failed. And sometimes these same communities in the third world and these countries have benefited from biopiracy. So I want to use Brazil as an example. I am a Brazilian national, so of course my mind tends to go there. And I want to use two plants that do not necessarily have medicinal properties, but that are very important in economic and other strategic kind of terms. One of them is rubber. So Brazil was the first country in the world to develop rubber, right? Because the trees that produce rubber as their natural sap exist only in the Amazonian forest originally. But of course, over time, rubber became such an important strategic material that it was considered to be a major risk to international markets, that everything hinged on Brazil, that Brazil could exploit that monopoly at the expense of humanity. And I'll come back to this confrontation later. So as a result, what happened? A lot of rubber plants, small plants, were smuggled out of Brazil to Southeast Asia, where the climate conditions were similar, so they could grow there and then kind of break the Brazilian monopoly. And that, of course, led to a lot of problems for the Brazilian economy at the time, but in a sense has, quote unquote, democratized access to this strategic raw material. And of course, since synthetic rubber became much better, so we don't rely on natural rubber quite as much. But it all happened on the back of undercutting Brazil. But Brazil also benefited from biopiracy. For much of the 19th and 20th centuries, coffee was Brazil's major export, except that coffee is not indigenous to Brazil. Coffee was smuggled into Brazil, or smuggled out of countries in Africa and the Middle East into Brazil, and then it became a major export because, again, climate conditions, but a system of where farming could be more easily structured towards higher yields and exports. There's always a lot of back and forth. A lot of countries in the global south tend to focus on how they have been victimized by biopiracy. And I understand that impulse, but there's also a lot of ways in which these countries, a lot of these same countries have benefited from biopiracy. So traditional knowledge speaks a lot to this kind of conversation about biopiracy, and the impulse behind traditional knowledge is to curb or stop the illicit movement of this knowledge without the consent and the benefit going to the state where this knowledge originated and the community where this knowledge originated. But mega biodiverse countries, they're constantly under threat of plundering or having to give away their knowledge for the benefit of humanity. So a lot of the conversation around rubber, for instance, at the time, as a strategic raw material in the context of wartime in the 20th century was that rubber is too important for the maintenance of international peace. Therefore, it would be selfish of Brazil to not give it away for free. Or if they charge any price, it should be a very, very low price. Or if we don't like any of that, we're just going to take it to Malaysia, which is what happened in the end, right? And in this sense, there's no clear sovereignty over these intellectual or cultural resources, which is the knowledge associated with traditional knowledge, right? The K part of TK, unlike what we have with permanent sovereignty over natural resources like oil or minerals, despite there being calls when countries in the global south were gaining independence in the 19th and 20th centuries. They all were very clear, all these countries, particularly not only in the Americas, but also in Africa and Asia, they were all very clear when they were gaining independence that they wanted to be able to safeguard the natural wealth of their country and the ways in which the nationals in those countries could deploy or have exclusive monopoly over those resources, because that was how their economies were built once they were forced into a globalized market by colonialism. So they wanted to kind of protect that. But those countries in the global north rejected those calls and said, no, now that we have benefited a lot from them economically as your former colonial overlords, we want to keep benefiting from it by calling it instead something that benefits humanity as a whole, and it would be selfish of you to keep your own resources and the monopoly over their exploitation. So I tell this story, which starts mixing a lot of elements from just legal history and international economic law to set up kind of the spirit that in many ways I believe underlies a lot of our conversation around traditional knowledge and a lot of what the treaty, the GRET, does for traditional knowledge. So that's kind of the general background. And then international law in relation to culture, more specifically, has been very concerned with protecting culture from undue appropriation for at least 50 years. Yet the evolution of the law in this area has been very slow and often co-opted by other interests, such as general international economic law, which is the story I was just telling you. So the question for us to consider today is whether the 2024 Genetic Resources and Associated Traditional Knowledge Treaty gets us to a good place when it comes to these resources. And my thesis to you, or my argument today, is that international law is still too stuck in an extractivist logic, which is grounded in a sense of entitlement to the quote-unquote common heritage of humankind as sort of the emperor's new clothes. and what's at stake in this argument, which is deliberately provocative on many levels? Well, if this argument is correct, then the Genetic Resources and Traditional Knowledge Treaty, which will be 1 year old, by the way, just later this month. I'm speaking in May 2025. The treaty is from the 24th of May 2024. So this treaty, it attempts to promote a seismic shift in how we frame these conversations around culture and knowledge in the law. So if you can recast our conceptual frames, that will invariably affect the implementation of this treaty, we can still have a chance of having this treaty help us upend the extractivist logic of international law. But we need to be aware of that extractivist logic, and there's a lot of work ahead for us. So how am I planning to convince you of this argument? First of all, I want to talk a little bit about international legal approaches to knowledge and culture more generally. Then I want to focus on two international legal instruments in particular, the Intangible Heritage Convention and the Genetic Resources Treaty. They sit with different international organizations: UNESCO for intangible heritage, the World Intellectual Property Organization for genetic resources and traditional knowledge. But again, they are the two major pillars of our conversation today. And I will add a few other instruments just to kind of contextualize the work of these two treaties, but I'll focus primarily on them. Then I want to talk a little bit about the implications of these two treaties and this major story, this bigger story about extractivist logic of international law to center identity and control over knowledge. Then I want to talk a little bit about tackling cultural appropriation, and then sort of wrap up this part of today's discussion. Now, when it comes to international legal approaches to knowledge, I would suggest to you that there are two main logics that we apply when it comes to international law in this area, which I'll call the logic of propertization on the one hand, and the logic of the commons on the other. So the logic of propertization, or the logic of property, is one that is very much driven by an individualistic or European Enlightenment kind of tradition, in which the author or the creator pours their soul into that creation and therefore needs to be rewarded as the individual responsible for this major breakthrough. And the logic of the commons instead will tell us that, well, all creation is on some level collective, right? Victor Hugo, when writing The Hunchback of Notre Dame, didn't come out of nowhere, right? It was because he lived in Paris, it's because the Notre Dame Cathedral was there, it's because he was interacting with other intellectuals and other thinkers that he could actually put together this masterpiece. So there's this idea in the commons that there's no such thing as fully individual genius. The genius or creation always kind of comes together with a whole community around it. But that's a logic that was largely silenced via European Enlightenment as a philosophy. So in a way, it's pre or Enlightenment, or works around Enlightenment. And at least on paper, it's also an anti-capitalistic kind of logic. The logic of property sits primarily with the World Intellectual Property Organization, as far as regional or as far as specialized bodies of the United Nations goes, and the logic of the commons sits with UNESCO. Why do I say that? Because the World Intellectual Property Organization, well, property is literally in the title, and UNESCO is the United Nations Education, Scientific and Cultural Organization, so it frames the knowledge as culture, and culture is sort of everywhere, right? Then needless to say, also, the logic of property is very much geared towards private law or private interests. The logic of the commons is geared towards public interests. So propertization relies on intellectual property, and the logic of the commons relies on the idea of cultural heritage. Another consequence then is that the logic of property then is very closely affiliated with economics, hence the capitalist kind of undertone, and the anti-capitalist sort of idea underlying the commons turns this conversation into culture instead of economics. but culture almost as an exception to economics. It's an opt-out of the economic system. It's a carve-out to the economic system. The logic of property also tends to focus more on innovation, right? So knowledge is new and moves us into the future, whereas the logic of the commons tends to focus, look, the knowledge comes from the past, and sure, it may affect the future, but primarily we're trying to trace for the origins of that knowledge into the past, and kind of, so we're more worried about the lineage of that knowledge in the logic of the commons, whereas the logic of property assumes that day one is when this individual genius came up with an idea that is going to shape our future. And of course, all these separations, they're not as stark in practice as I've cast them here, but I've cast them in rather in this sharp contrast to help us understand that there is something going on depending on the label you apply to traditional knowledge and the genetic resources that underpin it. So the separation between the property and the commons, I would suggest to you, it allows for extractivism. So the global south ends up kind of relying on the logic of the commons, partly because they are not in a position to defend individual rights necessarily, or we see the global south as unworthy of these individual rights. And we can see that a lot through the history of the investment law regime, for instance, and the historic unequal treaties that underpinned a lot of our economic relationships between the global north and the global south, especially in relation to European countries that could not conquer certain European territories, or even in an immediately post-decolonization kind of context. So these collective rights that the commons kind of catalyzes, they serve the state, yes, but only via specific economic logic in which the global south relinquishes raw materials to the global north in exchange for fast cash for development. And in this context, it is the exception and not the rule to promote, to use this money to promote long-term development. So we still kind of maintain this idea that all the cash that comes into global south countries for selling their raw materials, they actually never turn into what we would call today a knowledge economy, and rather they kind of disappear in paying interest to lenders in the global north, or they just kind of disappear in the local subsidiaries of transnational corporations that then send all their surplus capital to the back to the global north. So in this logic of extractivism, the creators and custodians of traditional knowledge, they end up caught between the rock of individual property and the hard place of states' prerogatives over heritage. It's useful to remember that when it comes to cultural heritage, the state tends to hold a very firm prerogative and control over the meanings of heritage, because heritage historically has been associated with the construction of the national identity and nationalistic kind of projects. So the creators and custodians of traditional knowledge, in this process, they remain voiceless and therefore without remedies. And if the Roman law maxim of ibi jus ubi remedium applies in the positive, then it also needs to apply in the remedy. If there's no clear law, there's no clear remedy. But note that this binary conversation was not always as separate as it has been since probably the 1990s. And there's a long history of cooperation actually between UNESCO and the World Intellectual Property Organization, or WIPO, in this area, which is what I want to turn to now in contextualizing the Intangible Cultural Heritage Convention and the Gratkin. Now, we need to look at this history of collaboration between UNESCO and WIPO to understand how this binary between the logic of property and the logic of the commons have crisscrossed over time. But this thematic crisscross does not resolve the binary in any way over time. It just kind of happened, and then it seems to move in another direction, as in a pendular sort of movement, or just kind of get abandoned over time as these initiatives kind of go on. And the first moment in this history that I want to highlight goes back 70 years now. which is the Universal Copyright Convention, which for the first time kind of starts thinking about what happens, which is a treaty about individual rights for individual creators. But for the first time, it starts at least asking the question of what happens when you cannot attribute authorship, individual authorship, to something. So it starts kind of at least asking the question of the commons, or admitting that there is a commons out there. But it doesn't resolve it. It's only the 1967 Stockholm revision to the Berne Convention, again on authors' rights or copyright law, that we start thinking about provisions for what we would then call folklore, and today we would call intangible heritage, which is provisions covering artistic creation that has fallen into the public domain, but it is tied to a specific community or set of cultural practices. So the Stockholm revision starts kind of addressing that. And it's the first time we have an international legal provision on the matter of sort of trying to harness the commons in a way that does not kind of give it away, quote unquote, to the world. Still kind of safeguards, or at least is mindful of the rights of those collective kind of creators. Now, that's 1967, and then the next moment I wanted to highlight is that in 1973, 1 year after the World Heritage Convention was adopted by the UNESCO General Conference, Bolivia came to the table saying, you know, World Heritage is all fine. We love sites, we love big things, but what about things that are not covered by sites? What about indigenous knowledge that is not embodied in a monumental physical space? How do we protect that? So that was the first call in 1973 for what eventually 30 years later will become the Intangible Heritage Convention. So it's important to highlight that the Intangible Heritage Convention, at its very deep origins, is concerned with indigenous knowledge in the first instance. But nothing comes out of that proposal, at least not straight away. Instead, what we have in 1976 is the Tunis Model Law on the rights of, on the possibility of creating individualized copyright or some form of copyright protection for folklore. It's a model law, which means it's just provisions for states to adopt in their domestic law. To the best of my knowledge, last time I checked, which was admittedly a couple of years ago, not a single country had actually incorporated the Tunis model law into domestic legislation. But it was a good moment to start having a debate about what to do, or at least be mindful that there were calls to redress this kind of appropriation of knowledge. And then in 1978, UNESCO and WIPO formally begin to collaborate in this area, and that leads to a number of initiatives, such as the creation in 1982 of a UNESCO Committee of Governmental Experts on the area of folklore and intangible heritage, which then covers also traditional knowledge. In 1982, the work of this Committee of Governmental Experts has an early success in the form, again, of model provisions for national law, which, much like the Tunis law, never quite go anywhere, but it kind of stay there in the ether. And it's something that international lawyers kind of like to go back to those early initiatives as a model for future international law developments, because even just having a text of any sort kind of helps get people used to the idea and slowly build consensus around it. But that was in 1982, and then fast forward to 1989, we have a recommendation under UNESCO on the legal protection of folklore, which was in many ways a big success, but it is a recommendation. It's only soft law. It doesn't bind any states. The first kind of binding provision comes here in 1992. That is a full 25 years after the Stockholm revision of the Berne Convention, which had been the previous kind of hard law sort of provision, and that's a Convention on Biological Diversity. The Convention on Biological Diversity doesn't sit either with UNESCO or with WIPO, but it is important to bear it in mind because it's the first international treaty that talks about traditional knowledge upfront. It's also an incredibly successful treaty. 196 states around the world, 196, so that's every UN member state, has ratified that convention. And part of it is Article 8J of the convention, which says that subject to national legislation, each contracting state shall respect, preserve, and maintain knowledge, innovations, and practices of indigenous and local communities embodying traditional lifestyles relevant for the conservation and sustainable use of biological diversity, and promote their wider application with the approval and involvement of the holders of such knowledge. So it's the first time an international treaty talks specifically about traditional knowledge. It's the first, but it is a treaty about biological diversity. So this knowledge needs to be very much geared at protecting the environment, right? So that's kind of the spirit of it. It's not what necessarily happens in practice. The environmental spirit is always there in the implementation of this treaty, but it sort of takes off as well because it's the only thing that people have to hang on to in its own sort of ways. So why is it important to mention that the environmental spirit stays there? Because the environmental spirit is very cosmopolitan. So there is this real sense in the Convention on Biological Diversity that that knowledge is there as a gift to the world. It's something that traditional communities ought to gift onto the world for everyone's benefit. So this is the idea of the common heritage of humankind underlying this provision, even if it does talk about the approval that these communities need to give for their the uses of their knowledge. All right, so put a pin on that. I'll return to it in a few years in this timeline. But before that, I just kind of wanted to mention a couple of other things that happened in the 90s as well. Shortly after, or the next year from the adoption of the Convention on Biological Diversity in 1993, UNESCO created the Living Human Treasures program, which was a means of highlighting the individuals in many ways that created or kept alive intangible cultural heritage. So it sort of tries to bring a bit of that individualistic logic of creation onto our thinking about cultural heritage as well. It's a fairly successful marriage of ideas to the point where the national legislation of a number of countries, particularly in East Asia, emulates this idea and focuses on living human treasures as individuals who deserve certain status. But for the most part, UNESCO sort of moves on to thinking about the cultural practice, as is the logic of heritage in other treaties under that organization. In 1994, a big thing happens that is important for our purposes, which is the establishment of the World Trade Organization and the TRIPS agreement, which is an annex to the WTO treaty on trade-related aspects of intellectual property law, which ends up forcing the World Trade Organization even closer to UNESCO, because the TRIPS agreement from the World Trade Organization kind of makes WIPO irrelevant in many ways, because it replaces all of WIPO treaties in some respects. So WIPO sort of needed something to do, which is why in 2001, it created an Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions. Fiona Macmillan makes the argument that the Intergovernmental Group, or the IGC, was created to give states or give WIPO something to do. And it was a mandate that originally kind of brought together genetic resources, traditional knowledge, and traditional cultural expressions. And then this mandate got separated and then brought back together. It was a very slow-moving process here, to the point where it took 23 years for the first treaty to come out of this process. And we'll come back to that treaty in a minute. But it's important to bear in mind that one of the big ideas behind the IGC process was to essentially reinvent all of intellectual property law. They had this ambition to rethink how intellectual property law worked and move it beyond the logic of proprietization that I was talking about earlier, and better integrate the commons. And they did that partly by collaborating with agencies like UNESCO, the Food and Agriculture Organization, which is here in Rome, the Convention on Biological Diversity Secretariat, but also by including a lot of indigenous peoples into the conversation. Now, the process dragged on precisely because of the ambition and the inclusion of indigenous peoples, because a lot of the states participating in this process, they were not comfortable with handing over the reins of intellectual property because of its massive impacts on the global economy to indigenous peoples. So they kind of slowed it down as much as they could. But, you know, we have a treaty after all. But before I get to that treaty, I just wanted to quickly mention the Intangible Heritage Convention of 2003, which is one of the major signposts that we have for today's purposes. The 184 states have ratified this treaty, and all of them are also parties to the Convention on Biological Diversity, I must say. So there's a clear relationship here between this treaty and these two treaties. And Article 3B of the Intangible Heritage Convention actually says that nothing in this convention may be interpreted as affecting the rights and obligations of states parties deriving from any international instrument related to intellectual property rights or to the use of biological and ecological resources to which they are parties. So the Intangible Cultural Heritage Convention is subordinate to the Convention on Biological Diversity, and arguably even subordinate to the Treaty on Genetic Resources and Associated Traditional Knowledge. At the same time, though, intangible cultural heritage as living heritage is a much bigger concept than traditional knowledge. It encompasses all of traditional knowledge, but not all of intangible heritage will be traditional knowledge, but all traditional knowledge is intangible heritage. The main mechanism for which the Intangible Heritage Convention wants to pursue or prosecute its objectives is through listing and visibility. So it buys very much into the logic of the commons, but one that is anti-capitalist, right? So it tries to opt out of economics, at least initially, but that's something that has recently changed. And the community becomes very central to this process. And the Intangible Heritage Convention is really important as well because it contained groundbreaking norms in terms of community participation in this space, which at the beginning were implemented in a really complicated sort of way, which was not great. But a lot of credit goes to the UNESCO intangible heritage bodies and the experts such as Benedetta Ubertazzi, who helped drive a lot of that change within UNESCO. But it's still stuck in nationalism in a lot of ways and kind of neglects or leaves the communities a bit voiceless, at least at the international level. We're getting better, but not quite there. In 2010, in relation to the Convention on Biological Diversity, the Nagoya Protocol to that convention was adopted, and it came into effect in 2014, which has important provisions on access and benefit sharing. So it tries to kind of move past or kind of elevate that logic of traditional knowledge is useful because it contributes to environmental conservation. So traditional knowledge can be a thing in itself, and communities ought to benefit from their traditional knowledge through access and benefit sharing, which is a wonderful kind of idea, and it foregrounds contracts, which is a big advance here in enabling the voices of communities in this conversation. But it is still one in which communities get to have access and sharing the benefits of someone else exploiting their knowledge. There's not an awful lot there about helping communities exploit their knowledge themselves. And that's something to bear in mind. But it's a very successful international instrument with 142 parties around the world, of course, all of whom are parties to the Convention on Biological Diversity as well. And then finally, we get to the Genetic Resources and Associated Traditional Knowledge Treaty of the World Intellectual Property Organization, which opened for signature on the 24th of May, 2024. It is open for signature for another few days until the 24th of May, 2025. And so far, there have been 41 signatories to that treaty and 1 ratification only from Malawi. The treaty needs 15 ratifications to enter into force, but 1 year in, it's not uncommon for a treaty to have low ratification numbers because it takes a lot for states to ratify treaties because they have to change their domestic law and so on and so forth. Out of these 41 signatories, which in good faith are committed to this treaty under the terms of the Vienna Convention on the Law of Treaties, except for Australia and Switzerland, all other signatories of this treaty are Global South countries. And Australia also has a lot of indigenous peoples and an interest in using intellectual property to protect their culture. So effectively, only Switzerland is a purely extractive sort of country. All the others are source countries for traditional knowledge. And that's a complicated dynamic because it means that in some respects, the treaty can be less than amazing in protecting traditional knowledge or protecting the holders of traditional knowledge if countries in the global north who extract that knowledge do not agree to its rules. But out of these 41 signatories, all of them are parties to the Convention on Biological Diversity, and nearly all of them are also parties to the Intangible Cultural Heritage Convention, except for Australia and Niue, who are not parties to the Intangible Heritage Convention. That said, out of the 41, 9 of them are not parties to the Nagoya Treaty, to the Nagoya Protocol, and what does that tell us? That there is still a bit of a mismatch between this idea of using contracts, which is what the Nagoya Protocol does, to kind of break the logic of property, versus kind of using a property kind of device, which is what the GRATC does. To curb these extractivist logics. But how does the GRATC actually try to break away from this extractivist logic of property? Well, the scope of it is to create an exception to prior knowledge in patent applications. Under patent law, you cannot get a patent for something that is not new. So if you can prove that the knowledge already existed, was already out there, the patent can be rejected. And the GRATC tries to create a mechanism through which you can prove the existence of prior knowledge by forcing disclosure requirements on patent applicants when they are using indigenous knowledge. But again, if these patent applicants are countries in the global north and no global north country is a party to the GRATC except for Switzerland and Australia, then what are we really doing here? But, you know, at least on paper, the GRATC imposes a burden on those seeking a patent to disclose this, the use of indigenous knowledge. And that's a big pro of the treaty. Another advantage of the treaty is this provision on Article 6 about the co-design of information systems for people to access and catalog indigenous knowledge, which is to be done in consultation with indigenous peoples and local communities. And that's one of the small ways in which indigenous voice kind of gets to the table. Another advantage is that the treaty admits for no reservations, and therefore the countries cannot free ride on the treaty and say we are a good state, we're doing the right things by ratifying the treaty, and when you look in the detail, they kind of opted out of the key provisions. They cannot do that. But it also means that states will be more resistant to ratifying in the first instance if they cannot make reservations. And that kind of gets us to the cons or the disadvantages of the treaty, is that for the most part, except for this provision on co-design of databases and information systems, the voices of indigenous peoples and local communities tend to be buried alongside their interests. The logic of the treaty assumes that indigenous peoples can apply for patents elsewhere, but does not offer them any support to do so. It's also a non-retroactive treaty under the terms of Article 4, which means that any biopiracy, any appropriation of indigenous knowledge or local community knowledge that happened prior to the entry into force of the treaty for the relevant state is all of a sudden off the table for contestation, and those patents will remain valid. And that's a similar logic to other heritage treaties, but it's still kind of a bummer as far as indigenous peoples and local communities are concerned. So looking at this treaty in contrast with the Intangible Heritage Convention and the other instruments and initiatives I mentioned, are we still stuck in a privatized and extractivist logic? Yes. Especially in the GRATC. It's a very much an extractivist sort of treaty, or it doesn't necessarily stimulate more extractivism, but it does very little to counter the extractivist logic that underpins intellectual property law. which means there's a lot of scope left for the Intangible Heritage Convention in bringing the conversation about the commons more to the fore. But then the question is whether this heritage logic, this commons logic, can fix the holes that the GRATC was meant to address. Because again, remember that the scope of the IGC, the mandate of the IGC, was to reinvent intellectual property law. But it doesn't do that. And can the Intangible Heritage Convention do that via a mutually supportive interpretation of the GRATC, which is mandated by Article 7 of the GRATC? Not really. So in other words, this treaty, the GRATC, does not live up to its promise. Its text is still burdened by a reluctance to append the logic of property and private rights, carving out an exception to these rights, rather than the reinvention of intellectual property that the WIPO IGC promised. And this exception is a good idea, but something else that it does is that it invariably reinforces extractivism as the baseline within which we operate. It says it's okay to operate as a baseline because now we have an exception. But every time it's an exception and not a change in the baseline, the baseline tends to be reinforced. So thinking about then the big topics of identity and cultural appropriation in this space. On cultural appropriation, I like to rely on the work of Dr. Aila do Valle Alves, who has published this great piece on ISIL Reflections last year, right after the GRATC came into existence. So she thinks of appropriation as, in the broad terms that we have been discussing, right? It's taking without consent, ignoring indigenous voice and agency, treating indigenous peoples as a resource or a good savage who benevolently surrenders themselves for the benefit of the cosmopolitan project of the common heritage of humankind. How do we address appropriation? Well, key themes need to be on the table. The recognition of indigenous peoples as rights holders, the accommodation of indigenous worldviews, participation, remedies, and control. Now, the GRATC sort of addresses all of them or tries to address all of them, but it's very light touch because the starting point of the treaty is not indigenous worldviews, which actually barely feature in the treaty itself. It is a pre-existing colonial arrangement. So if you don't take indigenous worldviews seriously, you cannot actually do the work of transforming the extractivist system because it will always be a necessarily unequal, asymmetrical system. And the same sort of happens with identity, right? Except that the big difference here between cultural appropriation and identity is that, of course, identity is much closer to the heritage logic than to the property logic. But then what identity does is that it tends to separate technique from the creator, right? Because only artistic creation has a soul and only artistic creation is therefore tied to identity. So it kind of creates, the use of identity creates an obstacle for us to leverage indigenous peoples when it comes to technical knowledge, such as traditional knowledge. Because again, remember that traditional knowledge, contrary to patent law, does very little with technique in the first place. And even the little that it does is kind of taken over by this idea that it's just nature, right? And they were just lucky to stumble upon this plant and make use of it. Now, the GRATC also makes no reference to identity whatsoever, except that, of course, if we're thinking of a reinvention of intellectual property law as an anti-economics or an anti-globalization move, we should be thinking about identity more seriously. Then the question becomes whether identity can be adequately anti-extractivist. Sort of. We can try to use identity to leverage this anti-capitalistic kind of logic, anti-capitalist logic, in the sense that it attempts to create or carve out the discussion of economics, but understanding that it is difficult to win in the terms of the property conversation. So it brings commons into the conversation because property is a battlefield where it's too hard to get a win. But then the question becomes whether avoiding a fight actually means winning it. And, you know, I'll leave it up to you, or maybe the commentators to say more on that. And if these treaties don't actually give us the fix, and I'm mindful that I'm over time, the question is whether human rights can fix these problems, because human rights have a tendency to foreground identity more than these treaties we've been talking about so far can do. And here, looking at the soft law instruments, such as the UN Declaration on the Rights of Indigenous Peoples, the American Declaration on the Rights of Indigenous Peoples of 2016, and the Declaration on the Rights of Peasants of 2018, all of them recognize rights holders, which is one of the items in thinking about cultural appropriation, and they have provision on the recognition of worldviews, participation, a form of control, and they are grounded in identity. But the provisions on remedies in these instruments, largely because they are soft law instruments, is still very much a work in progress. The focus tends to be on recognition over redistribution, and you cannot really fix the problems of intellectual property law without doing a bit of redistribution. So identity can be an entryway for reintegrating control as ownership, but it's still a bit limited on the economics. So can we resolve extractivism through these human rights instruments? Arguably better than through the GRATCA, in the sense that at least they do not attempt to bypass the market and focus on control rather than opting out. And where does the Intangible Heritage Convention stand in this conversation? Well, identity is very central to the Intangible Heritage Convention, of course, much more so than the Generic Resources and Traditional Knowledge Treaty does. And it offers a clear pathway to speak to communities and center their worldviews. And these worldviews, of course, are very much intangible heritage. So in conclusion, appropriation is a problem still in need of a solution. The incrementalism of the GRATCA is still too stuck in responding to an extractivist logic and thereby largely normalizing this logic as a baseline. And the Intangible Heritage Convention may still provide better avenues than the GRATCA, particularly through participation mandates read through human rights mandates on control. Thank you for your time. I look forward to our discussion.
Thank you very much, dear Lucas, for so interesting conference. Well, before giving the floor to Benedetta, I would like just to underline some points. I really liked your approach about the dichotomy on global south and global north. It's interesting for me to note that if we study the three international convention or treaty on this topic that you mentioned, ICH UNESCO Convention, the WIPO Treaty, but also the CBD, the Biological Diversity Convention, we have to underline that all of this convention was born thinking to the global south. When the 2003 Convention of UNESCO was adopted, the origin, as you know very well, of this convention was to give an opportunity to the global south to valorize and discover also the kind of heritage that they have, in contrast with the other UNESCO convention adopted in 1972. The same reasons, as you explained, was based on the WIPO Treaty, but also on the Article 8 of the Biological Diversity Convention, and also on the Nagoya Protocol that was adopted within the CBD Convention, and that was the first legal instrument, international legal instrument, that tried to protect the traditional knowledge on natural basis in Global South. But what we realized after several years of the adoption of the 2003 Convention and the Nagoya Protocol, that the origins of this convention was the request and also the necessity to establish new legal instrument for protecting Global South. But if we go on the implementation of this instrument, if we see this, what we realize that the North countries used this convention. If we see the UNESCO convention, well, after 20 years, more than 20 years, European countries or very developing country from America and Asia used a lot this convention, not for safeguarding intangible heritage, but sometimes, unfortunately, often, for trying to give a lot of visibility for their heritage. And the Global South is totally underrepresented in the 2003 UNESCO Convention. But it's the same for the Nagoya Protocol. The implementation of Nagoya Protocol after more than 20 years, if I don't make a mistake, it was adopted in 2010, but yeah. So 2010, no, 15 years, okay. The provisions of the Nagoya Protocol was used only in very few cases. So I think that there is the risk that also this treaty will be used by the global north and not the global south. You say that there are only two countries from the north, Australia and Switzerland, that decide to sign this convention. So we will see this treaty. So we will see what happens. But this is my first consideration. The second one. It is true that these three different international legal instruments are very different. The definition provided by UNESCO Convention of Intangible Cultural Heritage is very wide if we compare it to the definition provided by the WIPO, Treaty on Traditional Knowledge. Probably I can say that traditional knowledge represents a part of intangible cultural heritage, but the definition of intangible cultural heritage is very, very wide than the traditional knowledge, the definition provided by the Traditional Knowledge Treaty adopted by WIPO. But at the same time, we have to say that the effects of these different legal instruments is totally different. We know that we cannot use ICH convention for giving a patent or for recognize the ownership of the knowledge by a single community or person or individuals or people. But in the reality, unfortunately, the UNESCO Convention was used for this without any legal consequence, but for example, in two European cases, we have to say that the European Court of Justice recognized the fact that if an element is inscribed in the 2003 Convention, well, this means that the element is of the people that live in that community. And when another community tried to inscribe in the European context the label of the origin of the product, a similar product, the European Court of Justice say it's not possible. And one of the elements based on the judgment was the inscription of the element in the ICH Convention. So it is true in theory that the effects of this instrument are totally different, but we have to see also in practice and not only in theory. So I agree. I totally agree with you when you say that there is the overlap of these different instruments. And unfortunately, and I conclude, doesn't exist a global forum that try to coordinate these different instruments. Several years ago was established an open working group between CBD, Convention on Biological Diversity, and UNESCO, try to, and I was part of this open-ended working group, but ended. Probably never started. But apart this case, doesn't exist a global forum. This means that all these international treaties follow a different path, and there is no moment of confrontation. And this is very problematic for me. So probably we have to lobby these different international organizations and try to imagine a more close relationship. And I don't know in which way they have also to formalize on the same topic this the different approach, these different relations. Well, thank you very much, Lucas, again. And I'm sorry if I had this consideration. Benedetta, Benedetta Ubertazzi, as I told you before, she is professor of European law at the University of Milan. She is professor also of international law. She has a strong CV. She is one of the prominent experts on ICH and intangible heritage. She is part of the network of ICH UNESCO facilitators. She was one of the founder members of this network. So, Benedetta, the floor is yours.
Thank you very much, Pierluigi, for this very kind introduction of yours. To me, it is really an honor being here with you and a great pleasure because I have two friends sitting there. Lucas, who is one of my best friends because I always go to Sydney visiting him, and I will come again this summer. And then Pierluigi, thank you very much for inviting me, and yes, for introducing me in this way, and to the University of Unitelma and the UNESCO chair. This is a great honor. I remember being with Pierluigi in the first negotiations of the ICH convention. And I think that Pierluigi, Lucas, and me, we have a very good friend that is not sitting here, but is our mentor, so to say, probably of the three of us. And he is Professor Tullio Scovazzi. And I really think of him a lot today, hearing you and your speeches. And I remember during the negotiations of the ICH convention that we went through together with Pierluigi and with Professor Scovazzi as a chair of the Italian delegation. I do remember an atmosphere of great respect among delegations. And why am I saying this now? Because this atmosphere, to be honest, I didn't see at the WIPO negotiations. And that was a great difference that I just wanted to mention to the students, because this can help framing a bit my role as a discussant today, as Lucas did at the beginning of his speech. Framing the context. And I do think that this has a lot of sense, even for the students, to understand what happened in WIPO, which was completely different than what was happening at the UNESCO negotiations. At the UNESCO negotiations, you remember, Pierluigi, there is always, but in particular at the very beginning, a great respect. Delegates talk one to another using the term distinguished delegate, if I may, and this is the kind of languages that is used. And Pierluigi is a master of that. I learned a lot, really, and Pierluigi is really a genius in those negotiations. Well, in WIPO, the atmosphere was really shocking to me, because delegates were insulting one against the other. And the discussion was in this way. Some delegations of the Global South were saying, you are stealing our properties, you are using our resources, you are going against the rights of our people. So very, very strong language. And the US delegation, for instance, was replying, yes, but by doing that, we are saving millions of lives. What are you saving by keeping everything to yourself? And this was exactly the way delegates were talking one to the other, and I was really shocked coming from the UNESCO world, but this represents what we are trying to do today, to explain to you why this treaty, and Lucas was very good in contextualizing this. And if you think that that was the kind of context in the delegations, in the negotiations, where you usually use another language in international context, you may also understand how difficult it was to reach this treaty after more than 25 years. Then you look at the treaty and you're very disappointed, but still you have to understand the context was and still is very, very difficult. And why, if we have a look at the IP word, so very technical IP, patents people, and in particular pharmaceuticals, are very skeptical about all of that, because the disclosure requirement is putting on companies bureaucratic, because mainly they look at that as a bureaucratic requirement, which may weaken the patents. But you have to understand that patents is a compromise. It is a monopoly that state gives to companies, because if we think about inventors, we think about private individuals, but we should contextualize and think about companies that invest on researches a lot of money. And of course, they don't want to have their patents weakened. And if you think that the monopoly is for 20 years, but for pharmaceuticals, the real term is for 5 years. After that, a chemic is old. So you don't really care about having a patent. So you also can understand why these, for instance, this US delegate was saying, we are saving millions of lives. We are investing in doing so. So if you keep everything secret in your forest, then what? And if you put too much burdens on us, nobody will invest anymore, or what will happen is that companies will use traditional knowledge. So they will not patent, they will not disclose what they invented, because the patent is, as I said, a compromise. So you, company, you tell me what you invented, and I, state, will give you a monopoly. You tell me what you invented and you put it written down so that everybody can look at that and starting from there can invent more. If people don't trust in the patent system, companies don't use the patents, they are going to keep everything secret by using know-hows. Know-how is another intellectual property rights, but you don't have to disclose anything. You don't have to say what you invented. You keep everything secret. And then this may imply that at the end of the day, very few people know the inventing stage, and very few people will have the inventing skills. The rest of the world will be shut down. So this is the context where the negotiations occurred for 25 years, totally different context than UNESCO. Then what I wanted to say is that also when we talk about property, Lucas is right. Property is in the same word of WIPO, is not in the title, is not in the title of UNESCO. But even more so, property for UNESCO is what Chiara Bortolotto calls an embarrassment. So property is embarrassing UNESCO. When we talk about intellectual property, UNESCO people usually react, oh, no, this is for WIPO, this is for WIPO. And they are very embarrassed. And the same with marketing, okay? So you don't have to talk about marketing, you don't have to talk about property. So when you are in that context, things are changing, as Lucas reminded to us, and Pierluigi as well, because the same UNESCO ICH convention are using intellectual property and are saying to communities, in particular to states, use intellectual property rights to better protect your communities. And you, being the community, use to better protect your art. And even more so, tell us which kind of intellectual property rights you are using. Because in the nomination form, Pierluigi is an expert of nomination forms, there are sections where UNESCO wants to know which instruments are you, community, using to protect what you're going to list. And among those instruments, the operational directives mention in property. So many ICH elements mention intellectual property because they will gain the result if they do mention it and if they use it. If they don't, then the evaluation body may think that they're not protecting enough. So it's really something that is very strange in UNESCO. And we wrote an article with Chiara Bortolotto. On the one sense, property, they're very embarrassed, but on the other sense, they're saying use it. So very embarrassing, all of that for each of us. So in any case, then, okay, the commercialization, same thing. They say avoid over-commercialization, but Diego Rinaldo wrote, what about under-commercialization? This is also a problem, under-commercialization for sustainable development and so on and so forth. So up until now, misappropriations cases occurred a lot in the world, and WIPO and UNESCO witnessed about all of them already. And in some cases, some cases went to litigation states already, so without the new treaty, and communities could win the cases. How is it possible if there was no disclosure requirement until last year? Because there are other instruments in IP. So we don't have to rely only on the disclosure requirement. There is the bad faith legal instrument. So there were cases where, for instance, in the Lint trademark case, the European Court of Justice said the trademark is void. Why? Because it was asked and granted in bad faith, because it relied on traditional knowledge. As Lucas mentioned, we don't have to think just about traditional knowledge of indigenous people. What about Italian communities? What about, in that case, it was an Austrian community. So very far away from indigenous people, but still they have a traditional knowledge, and Lint was using it. So the trademark was declared void by the European Court of Justice. And there was no disclosure requirement in the trademark system, and still there is not, because the new treaty just focuses on patents. Then there were other cases. For instance, one of the most famous was the NAM3 case, where a patent was revoked because that tree, pharmaceutical or chemical was obtained a patent, but it was not a novelty. It was not an invention because it relied on a traditional knowledge related to that particular tree, which is located in India. And they could win already without this new WIPO treaty, without the disclosure requirement. And in India, we have one of the most important database of traditional knowledge that already exist. So we didn't need this WIPO treaty because we have already databases already available for patents examinators around the world. So which are the problems? As Lucas was saying, one of the problems is the prior art, okay? Because in some countries, like in the US, the prior art means just a local prior art. So whatever happens outside the US, this is not prior art for the patent system, okay? So this is the problem. So do we see this in the WIPO treaty? No. So even if you disclose in the US system, imagining that the US will become part of the new treaty, that the invention is based on the traditional knowledge located in India, will that be enough to say that the patent is not new, is not an invention that is new in the US, considering that US law thinks that prior art is only whatever happens in the US? So one of the main problems, and also really very much related to that, the applicable law. Which is the law applicable? So even if you ratify the treaty, every country should have legislation that is using the treaty as a model law. As Lucas was saying, like the model law was named model law, and no country adopted it for copyright. For this treaty, they didn't use the term model law, but this is a model law. Why? Because it doesn't say anything on which law applies. And this is the main problem, because if you think that the law that should be applicable is the law of the country of origin of that particular traditional knowledge, then things change. Because the US system then all of a sudden would have to recognize traditional knowledge occurring abroad. And this is something that in the Nagoya Protocol, we can see for the very first time, if I am not mistaken, is Article 16, that mention the law of the country of origin as the applicable law. But this is very technical. I don't want to enter into much more technical things than this. Okay, then Lucas is saying the identity. I agree. The identity is probably the turning point, is very, very important for the UNESCO ICH framework. Is very important also for systems that don't mention identity, but as Lucas was saying, mentioning ILA researchers, may have things that can be called identity, like the Nagoya Protocol. I really think that this protocol recognizes the identity a lot. Why? Because first of all, they say in the protocol the country of origin legislation is applicable, which to me is really a turning point. Also, as Lucas was saying, the Nagoya Protocol relies a lot on contracts, and in contracts, you can really protect the identity of one of the parties by including provisions that, of course, protect this identity. Like Lucas was saying, consent, benefit sharing, those are already in the model contracts that Nagoya system is introducing for states to use. So this is a lot to do for me, to me, a lot to do with participation, which is a concept that for Lucas is very important. I remember that Lucas was chairing an International Law Association committee on participation in culture and wrote a lot about that. So I agree, maybe the identity is the good wording that could combine all of that, the culture word and the IP related word, because Nagoya is not WIPO, you are right, but is CBD, and CBD bit related to the World Trade Organization and the TRIPS, which is really multilateralism. If you have a look at WIPO, and now I close, when they celebrated this treaty as a turning point, They put a video on the WIPO website saying in a time where multilateralism in international law does not exist anymore, we succeeded in having multilateralism. But is it really so? I mean, Lucas was reminding us how many countries are ratifying, where do they come from? They're not even ratifying, they're just signing the treaty. And are we really close to achieving a system of multilateralism like the TRIPS did by obliging countries that wanted to be in the WTO to sign the TRIPS? Or are we just saying that this is a multilateral context, but indeed we are not still there? So thank you very much, and I think I close with my comment.
And thank you very much, Benedetta. Lucas, at the end, if you want, you can also reply to this some very interesting suggestion. Thank you very much, Benedetta, also for giving us this inside view of the negotiation about the new WIPO treaty. And now I give the floor to Tiago Burkhardt. He is a researcher at the UNESCO Chair on Intangible Cultural Heritage here at the Uniterma Sapienza University. Before he was graduate at the University of Blumenau in Brazil, and he took a PhD in comparative law at the University of Caserta. And as I say before, his research focus is on the relationship between indigenous people and cultural rights. So, Tiago, the floor is yours. Thank you.
First of all, good morning, everyone. It is such a pleasure to be here this morning. Thank you, Professor Petrillo, for this possibility. It's not. Okay. Ecco. So, good morning, everyone. It's such a pleasure to be here. Thank you, Professor Petrillo, for the possibility. Thank you, Lucas. Congratulations for the brilliant presentation. Thank you, Professor Ubertazzi, for your reflections. And what I would like to do here is try to foster some critical reflections on the treaty, this new treaty, and the way it can relate to cultural heritage law as well. I divided it into 3 main points, and then I have some questions which are addressed to Professor Lucas, but they are very open questions, even because we don't have like the basis sometimes to comprehend the applicability of this treaty in practice. So those are open questions that all of us, if you want, you can also get into the discussion. The first point that I would like to highlight is the absence that I think it speaks loudly, which is the lack of a broader normative substance of the GRAD Treaty. I must confess that the first time that I read this treaty, I had the feeling that something was missing, and I was like searching for the other parts. I felt it was a draft. A draft treaty, but then I realized it was the real treaty. And I think this is very, something has been stripped away from the discussions, from the 25 years of discussions that the WIPO conducted with the participation of local communities, with the participation of indigenous peoples, but these voices kind of remained absent from the drafting of this treaty in general. So rather than proposing a completely different sui generis system, that maybe this treaty could be really a good forum for doing this, a good international forum for doing this, as it was doing at a certain perspective. The GRAD Treaty only settles for what we can call a procedural carve-out within the existing patent system, which is something that some particular experiences, national experiences, have already developed better, as Professor Benedetta underlined. And I think this reaffirms the state sovereignty over the cultural matters. But at the same time, it also seems to affirm and reaffirm a kind of market sovereignty over cultural matters, where the economic logic overrides the community control. And I think this idea of extractivism kind of illustrates it very, very well. So this exposes also the tension between the Intangible Cultural Heritage Convention, which centers the community, and the GRAT new treaty that remains deeply state-centric in general. So there is a clear, there is no clear mechanism for the enforcement of this treaty, as well as no clear mechanism for monitoring the applicability of this treaty, at least from its text. And the governance of this text will rely on the secondary norms defined by the states. Which reinforces the state, we can say the axis, the state market axis centric idea of this treaty. The second point is what I could call the betrayal of the community aspirations. No, the treaty not only lacks ambition, as I think a big part of the legal scholar community was expecting to, but it also falls shortly of what indigenous peoples and local communities have been demanding for decades in terms of traditional knowledge protection in international law. There is no formal, for example, recognition, as Professor Lucas touched upon these issues. No, there is no formal recognition of communities as legal actors within this treaty. The GRAT treaty makes no room for identity-based approaches, we could say. It contains no mandate, for example, for free, prior, and informed consent. And in contexts where the state is either absent or actively violating community rights, who can speak for the community? So this is an issue that raises from the treaty, but the treaty does not offer an answer to this issue. And the third point, I think it relates to the fragmentation of international regimes. And I think that the GRAT treaty intersects, of course, with CBD, intersects with ICH UNESCO Convention, but at the same time, it does not meaningfully engage with other legal instruments. I think they missed the opportunity for a real regime interaction between these and among these instruments, particularly with the legal framework that deal with cultural rights, with human rights, and with cultural heritage law. So in my opinion, maybe it leaves us with a more fragmented normative landscape where communities remain trapped between systems that refuse to speak to each other. So we have a more fragmented international cultural law than we had before. So taking this into consideration, I have basically three main questions. The first one is more theoretical, the second is more political, and the third is more legal. My first question would be, who's winning with all of this? Is it the market winning with all of this discussion? Not just politically, but also epistemically, in this entire conversation. And by reinforcing the procedural exceptions rather than a transformative principles within this legal system, does the GRAT deepen also this north-south divide in international law? And could it be considered a symbolic South-South treaty from the start? So this would be my first raising question. The second would be whose voice defines traditional knowledge in the GRET framework? Like, can a regime that depends on state intermediaries truly claim legitimacy? And when many indigenous peoples and local communities view those very states as extractive actors too, should we be moving towards legal subjectivity for non-state actors in the heritage field, for example? Could this be a way to overcome extractivism within international law? And the third is more provoking. GRAT, as a lot of as Professor Lucas suggested, but also Professor Ubertazzi pointed out, it kind of fails to deliver the justice and recognition in a certain way. But is that really a flaw, or is it a function of these of this treaty? Could it be that the treaty's role is not to disrupt cultural appropriation, but to domesticate the critique of appropriation itself, to translate it into procedural language that global governance can absorb without real redistribution and restitution? And in that sense, are we witnessing a political, or we could say a politic of not protection, but a politic of failure management within international legal system, where the legal innovation serves to contain rather than confront structural extraction? So these are my questions. Thank you so much.
Thank you very much, Tiago, also for these final issues that you put on the table. So I would like to give the floor to Professor Lidziński for the final remarks, and also if you want, because we are in a free country, you can also reply to the suggestion provided by Benedetta and the final question that Tiago put to you. Please, Lucas.
Thank you. It's such a pleasure to have such committed and insightful respondents and commentators. So thank you to all three of you, because I'll put you in that category as well, Pierluigi, in recasting a lot of the main ideas in what I was trying to do here. It's been really useful to kind of help me clarify where I'm trying to go, and I hope it helps clarify to the audience as well, both here in the room and live, but thereafter, who watches this recording, as to what's really at stake here. So look, so my major response is just thank you. There's a lot here for me to unpack, precisely in thinking about this idea of and kind of connecting something that both Pierluigi and Tiago said about, what can we actually hope for here? Can we hope for the creation of a global forum to coordinate all these initiatives? Is that the anti-fragmentation sort of move that would fix the problem? Or maybe the best we can hope for at this stage in international law, both from an institutional and substantive kind of perspective, the most that we can hope for is an incremental thing, that because it is incremental, maybe it offers not revolution, but a sneaky kind of evolution within the system, right? Is it enough to create a bit of a procedural problem as an escape valve for redistribution claims to actually be actualized, or is that going to fall flat? And I don't have an answer to this question because the treaty is not even in force yet, right? In force yet, but I hope it is a sufficient escape valve. But I'm also very mindful of something that Pierluigi and Benedetta and even Tiago reinforced, which is kind of this the gravitational pull of the economic dynamics in which Gratica seems to be inserted as a treaty, right? It is ultimately something that speaks to patent law without really challenging it, just creates like a small out. And I don't know, that maybe it is the crack that will undo the entire dam. But right now it just seems like it's decoration rather than actually functional escape valve. So that doesn't necessarily, well, it answers our questions by saying that I don't know, and just repeating something that I was saying earlier. And it is a problem that participation in the treaty to date, right? It becomes very south-south in its scope, as Thiago pointed out. But then getting to something that Benedetta was saying, yes, the treaty sits in a very uneasy kind of spot in the conversation as well, right? Because it does this little thing in intellectual property law without really tackling so much more in patent and intellectual property law more generally that could potentially have much more transformative kind of impacts. So we don't really do a lot of that work, which is what WIPO promised us they were going to do, right? It's what the agency was meant to do. So I'm frustrated because I feel like I was cheated out of a potentially great thing. But that said, there can also be just that incremental thing of just the way international law in general evolves, but particularly international law of culture, which is we put something out that seems kind of, to put it quite bluntly, dumb and useless. But it gets people used to an idea of something a lot more transformative, right? Because yes, we have the Gratica here, but the IGC is not gone yet. It's still working on traditional cultural expressions. It's still working on a broader text on traditional knowledge, as far as I remember anyway. So maybe the Gratica kind of gets people used to thinking about these exceptions, and then we can actually be more ambitious with the other two texts. Even though looking at the latest draft of both of them, there are so many square brackets, which is diplomatic lingo for this is a contentious kind of suggestion, that I don't know where we're going to go with any of it. But, hope remains. But at least being mindful of how the Gratica doesn't do as much work as we were promised it was going to do. If anything, gives us a chance not to pat ourselves on the back and say, job well done, but say, look, this is a starting point, but let's turn this crack into the dam, into destruction. And maybe something better will come out of it. Yeah.
Thank you very much, Lucas. I think that we spent at least 2 hours on this very relevant and new topic. So we really thank our speakers today, Professor Lucas Lidzinski, Professor Benedetto Bertazzi, and Professor Thiago Burkhardt for being part of this discussion. We will continue discuss about this topic because there are a lot of things that we have to discuss, and I think that a seminar like this can contribute also to the right implementation of this legal instrument. So thank you very much, and we will see you on the next at the next seminar. Thank you.
Grazie Benedetta. Ciao, alla prossima.
Grazie, ciao. Vieni a Milano, Lucas.
Siamo
Vieni
là, vero? Aspettate, we are... Benedetta? Sì.
Mi senti?
Yes, just 1 minute. Ok, no, è che eravamo ancora online, quindi prima di dirti